Don't wait for criminal sessions. I would like, where's my phone? Now, my Lord the Party President, I would like PFF not to make the mistakes done by other political organizations in approaching the Uganda Law Society. Upon assuming office of President Uganda Law Society, I asked our head of the legal aid project to tell me everything about the Olivia Otaya case as far as Uganda Law Society is concerned. And she sent me this email. Dear Mr. President, I decided to go through our old emails after talking to you, just to confirm if I've ever received any complaints from Olivia Otaya and others in a similar situation. I got an email where I was responding to the past President Bernard Owundo. I have forwarded the same to you for your information. Thank you. Awori Christine, Head Legal Aid and Pro Bono Services, Uganda Law Society. So the email she was sent was dated July 28, 2023. Re Olivia Otaya to the President ULS then. It was copied to other leaders, including our then CEO and head and our top gun, Mariam Nansukusa, top litigator there. Dear Bernard, Miss Olivia Otaya was arrested with 30 others and charged with illegal possession of explosives. Olivia and the 30 others are National Unity Platform supporters who have been on remand for 3 years. Olivia is at Luzira Prison Women Wing. 2 inmates are at Luzira Upper Prison and the rest are at Chitalia Prison. Olivia and the 30 others are represented by Counsel Katana Benjamin and Counsel Musisi George and have been appearing before the court-martial. They have made an attempt to apply for bail on 2 occasions, but the applications have not been granted by the court. Nonetheless, they intend to make a 3rd attempt. Counsel Katana advised that the legal aid project of the Uganda Law Society can consider offering them support in the form of psychosocial counseling, but not representation. Since he and Counsel Musi are already representing them. In addition, given the nature of the case and the parties involved, it is a politically motivated case which is outside the ambit of the legal aid project. And as the legal aid project of Uganda Society, we should not be seen to be partisan. Thank you. Awori Christine, Head Lab and Pro Bono Services, legal aid project of the Uganda Society. That is July 28th. So, 2 eyebrow-raising discoveries there, right? Well, the first one, I'll speak to it.
Join me to also welcome our chairman, Ambassador Omulongo Waswa Birigwa. Join me to also welcome our uncle, Elder Uncle Waf. Please stand up and wait for us.
A kafafo is a humorous sounding word for a mostly non-humorous situation, like the one you went through and have vividly described for us. Some kind of disturbance, scandal, or mess. So I will work from what I know about this kafafo in general regarding the case, much of which have garnered from media reports and associated statements from political organizations concerned, including the statement of the governor of Kisumu, Professor Anyang' Nyong'o. A group of Ugandan political activists had gathered in a Kenyan city in order to have a series of meetings over a few days. This means they were also staying in accommodation there. The venue was then raided by people eventually identified as Ugandan security operatives. They may or may not have been accompanied by Kenyan ones, but from what we've heard, there was a Kenyan contingent as the tip of the spear for this attack. Their identification as Ugandan security, comes largely from the fact that after being physically restrained, the Kisumu 36 were transported overnight and found themselves in Uganda, eventually being charged in a Ugandan court with various offenses. One reason for the meeting having taken place in a neighboring country was that some of the participants were asylum seekers there, having fled alleged political persecution in their home country. It therefore made sense for the party colleagues to travel and convene with them there. This presents several problems, questions, and challenges that are condensed here. In short, various laws, both international and national, have been broken in two different jurisdictions. Deeper than that is the principle of legal legitimacy that has also been violated. Let me speak about the historical crisis of legitimacy. The central challenge for illegitimate rule is that it suffers from a sense of deep insecurity, knowing deep down that it's only possibly accepted, but certainly not loved. In an attempt to resolve this dilemma, such power tries to invent and create its own sense of legitimacy. Two of the most abused routes to trying this are the law and culture. In the Ugandan experience, there was the business of deposing legitimate native rulers, but not abolishing their posts. Instead, new and more compliant persons were imposed on the posts and declared the new leaders. This is what we call neo-tradition. More broadly, they created and imposed a new legal system that they claimed will bring justice for all. However, it is hard, if not impossible, to build legitimacy on illegitimacy, or in this case, legality on illegality. In short, if you broke laws and violated cultures and customs in order to come to power, why should anyone really believe in the legal system you came with? This is why the legal system that we have should perhaps be called neo-colonial or neo-legal. Likewise, if you hold power through having violated electoral law, how can you expect to be taken seriously when you invoke the rule of law argument when dealing with governance matters? You cannot. People obey you not because your rule is lawful, but because it is forceful. Put another way, illegitimate power always finds itself reaching an inflection point where the very laws it came with have now become an obstacle even to itself, as far as maintaining power is concerned, and so it must violate them. This is where we are now. And we have been here many times before, both in relation to the duration of the current government, but also in relation to previous ones, since the very creation of the Ugandan state. The very creation of Uganda began with a series of abductions, where legitimate leaders were forcibly taken from one jurisdiction to another imposed one. Famously, our kings Kabalega and Mwanga were seized in 1899 and held in the Seychelles. They passed through Kenya, like you. The actually native leader, Awich Abok, was also abducted and held in what became Kololo for refusing to comply with the demands of the colonial invaders to reveal the whereabouts of Omukama Kabalega and Kabaka Mwanga before they were eventually captured. So you can see that it's a massive lie that there has always been a north-south divide. There has always been a north-south collaboration against invaders of these lands. The anti-colonization fighter, the Rwandan queen, Muhumuza Nyabingi, was also captured in battle in 1908, resisting Germans, the Belgians, and the British, and held in Kampala until her death in 1945. Many figures during later colonial rule, such as Josiah Kate and his colleague Malachi, and later his son Kamlegea, were also carried off to other parts of Uganda and simply held there in the 1910s and 1930s. All this happened even as the colonial authorities had erected, starting 1902, a system of courts, judges, prosecutors, laws, and the like, calling it a judicial and legal system. Today, you can get bail. In 1899, 1910, 1930s, they couldn't. After independence, we saw infamous cases like the former anti-colonial firebrand, Joseph Jolly Joe Chiwanuka, being abducted, again in Nairobi, brought to Uganda and killed by the agents of the then regime. This particular incident should be of special historical significance, since the late Jolly Joe is the paternal grandfather of Chiyowa Chiwanuka Nsumikambi Mugambe, Uganda's current Attorney General and frequent defender of regime constitutional violations. Now, some important clarifications or points need to be made here. Jolly Joe may have been kidnapped in Nairobi or apprehended at the border trying to enter Kenya. To ascertain this fact, we shall need the assistance of historians. But the essential point remains that he was seeking asylum, running away from the Idi Amin regime. After all, he had previously been detained without trial during Obote I. In fact, he was released along with other politicians after the Amin coup, only to die by the Amin regime. He had been arrested and sometimes tried and sentenced, possibly more times than even our good Colonel, Dr. Besige, during the colonial period. So in many ways, Jolly Joe, may his soul rest in peace, represents the effects of the crisis of legitimacy very well. Throughout the Amin period, a number of perceived anti-Amin actors were forcibly returned to Uganda, just like the Kisumu 36. These repatriations continued with the subsequent 1981 to 1985 Obote II government. For instance, the then chairman of the rebel group Uganda Freedom Movement, UFM, Balachi Chiria, was abducted in Nairobi and wound up detained in Uganda. There was even a famous failed attempt to grab Council Adoko Nechon, thank you very much. The then President Obote's first cousin, who then was in opposition, off the streets of Nairobi where he had sought exile. What these abductions all tended to have in common was the cooperation blind eye or collusion of whichever Kenyan government was in power. And this has happened again in the latest incident. Now, moving away from Kenya, and in more recent, there was the case of Jamil Mukulu, who was forcibly returned sometime in 2015 and brought to Uganda for a prosecution that has never taken off. 10 years in detention. But today we speak about Kenya. Uganda needs to get to a point where Ugandans have actually created their own judicial system, and therefore where governments have recognized that obeying the Constitution is always the best course of action. Constitutionalism and law must not be seen as options to other forms of gaining power, asserting power, and control over the affairs of our sovereign republic. They should be seen as the sine qua non, as my Lord Mayor would put it. The irreducible minimum, the lowest common denominator for all political action should be constitutionalism and the law. Freedom for all, all for freedom, freedom for all. As we've argued before, any regime that has not only rigged its way into power, but also arguably rigged the very Constitution itself, will always find it hard to act lawfully and constitutionally. There's only so far you can go with a pretense. Nevertheless, we must take all steps possible to continue to try and force this argument against all the odds. My dear Council, in charge of the case of the Kisumu 36, I therefore urge you to continue the representation within a framework that recognizes the context that has brought us here. Do not validate the prosecution for terrorism. That mistake was done by lawyers representing Jamil Mukulu. Jamil Mukulu personally asked me to go to Luzira and meet him. And I told him I'm here. But there's one condition: I'm a human rights lawyer and I will see this purely in a human rights lens. And that means you have to let go your other lawyers because they will see me as an obstacle to what I have to do. I have to challenge the state of Uganda for the way it got you. You are into the hands of the Ugandan state illegally. That's what you must challenge. Of course, the other lawyers wanted to do a bail application and do a trial, and they told him to wait for the, what do they call it? A criminal sentence. 10 years down the road, they are waiting for a criminal session. In that time, we could have done the following things that are similar to what I'm about to say. Number one, from the tales we have heard, there was an abduction in Kenya. And so the state responsible is the state of Kenya. It must be sued, or it must be petitioned, which I understand has already been done. Number two, there was an arrest, or to put it in the proper legal terms, there was an arbitrary arrest within the jurisdiction of Uganda. And so the state responsible is the Ugandan state, and it must be held to account in terms of Article 23 and Article 50 of our Constitution. No person, Article 23 reads, no person shall be arbitrarily deprived of their liberty except in the specified circumstances. none of those meets your situation. No person shall be arbitrarily deprived of liberty, and there are preconditions for an arrest, one of them being reasonable suspicion arising from probable grounds, which must be told to you. But in your case, I guess they want to do the investigation. And I think that's what they told the court, that the investigations are ongoing. So the arrest was clearly premature and uncalled for. This issue has to be interrogated ahead of the trial. Number 3, freedom of assembly. You were 36. Much of the kerfuffle is about your number. We have to start to defend freedom of assembly like it matters for all Ugandans. This right is enshrined in the UN instruments, especially the UN Declaration for Human Rights of 1948 and the 1966 Covenant on Civil and Political Rights. The state responsible here is probably the state of Uganda, which, of course, in collaboration with the state of Kenya. They broke up an assembly. They interfered with an assembly. This is what we need the court record to indicate. You must sue on those issues. Last but not least, there are refugee law considerations here. Unfortunately, time wasn't enough for us to get to hear them firsthand from the Kisumu 36. But from what I have read, I understand that there was breach of international protocols protecting asylum seekers. The UNHCR has important case law on these issues. We must present a report to the appropriate agencies, local and international. We must sue and we must petition. Kenya should be safe ground for Ugandans seeking asylum. From the history I have just shared, it appears not to be the case. And finally, prosecutorial misconduct. I have made the case before that you have a pumpkin for a DPP. But some lawyers continue to pretend that she is actually a DPP. And for some, they take it very seriously because they think it's an attack on womanhood. Or it's an attack on being Karima Jong. That's absolute nonsense. She's a pumpkin. She's dead wood. She's a dimwit. She's a careerist, shameless careerist. She's a cuckoo in the nest of our criminal justice system. You cannot, in 2024, hold the job of judge and prosecutor and imagine that you do no harm to that all these things, like your particular kerfuffle, is then given legal dressing by this vagina from Karamoja. We have to start to call things exactly what they are. So you need to take action against prosecutorial misconduct. You are entitled under Article 120, Sub-Article 5, to the protection of an independent defendant. This goes to you, Counsel. Let me see to what extent your youth is a prize. You got to